We also ask that you, if you could keep your mic off as well. The session is expected to last 90 minutes. The lecture will last approximately 1 hour total, and we will have 20 to 30 minutes for the Q&A. This Q&A part will be divided into 2 sections. One after the first part of the class, which is like the normative discussion, and other at the end. So you can pose your questions in either of those 2. We would like it if you could type in your questions in the chat box, and I will later read them to the instructors. If you want to direct your question to a particular instructor, please mention that in your comment, in your question. So now let me introduce you to today's instructors. Andrea Marcela Brusco is a lawyer graduated from the Universidad del Salvador School of Law in her home country, Argentina, and she holds a master's degree in international relations from the Latin America Faculty of Social Studies. Before entering in UNEP, Andrea was director in the Ministry of Environment of Argentina, and she is specialized in international environmental governance. Since 2007, she has worked in the Regional Office for Latin America and the Caribbean of the UN Environment Program. As legal officer of said entity, she has implemented projects in the countries of the region related to the development of legislation, institutional strengthening, and training in environmental law. Since 2014, she has been the regional coordinator of environmental governance, and in this capacity directs and implements the UNEP Global Environmental Law Program in the region. Maria Antonia Tigre is the director of Latin America for the Global Network for the Study of Human Rights and the Environment. Through GNHRE, she has increasingly focused her efforts on human rights-based climate litigation in Latin America. She is also a coordinator of the Human Rights Group with a particular focus on ecological rights for the Global Pandemic Network, a community of scholars created to debate legal aspects associated with pandemics. She is currently finishing her SJD in International Environmental Law at the Elizabeth Hobbs School of Law at Pace University. Finally, Daniel Noroña graduated with an LLB from Universidad San Francisco de Quito in Ecuador and holds a master's degree in environmental and energy law from Tulane University in New Orleans, USA. Additionally, he also received a specialization degree in ESCE rights from the Buenos Aires University. He is the Deputy Director for Latin America of the Global Network for Human Rights and the Environment, and a member of the International Network on Climate Change, Energy, and Human Rights. He has experience in issues related to development and human rights, environment, climate change, and international cooperation. Previously, he was an officer for the Attorney General Office of Ecuador and the Ombudsman Office of Ecuador. He currently serves as a consultant for Office of the Special Rapporteur on Economical, Social, Cultural, and Environmental Rights of the Inter-American Commission on Human Rights. And without further ado, Andrea, the floor is yours.
Thank you very much, Natalia. I am very glad to be with you this afternoon, this morning here in the home region of the Escazú Agreement. By the way, for those of you who yet don't know what Escazú, the word Escazú specifically means, it is the name of the city in Costa Rica where the agreement was adopted on the 4th of March of 2018, a city right next to San Jose, the capital city of Costa Rica. I am very glad and I am very honored to share this class with Maria Antonia and with Daniel because of their knowledge and expertise. My introduction on the Escazú Agreement will be focused on the process for building the Escazú Agreement. And let me say that this is a very interesting aspect of the agreement. The process itself is seen by us here in the Latin American and Caribbean environmental law community as an achievement for environmental governance in terms of how the agreement was built, how it was negotiated, and all what happened in terms of strengthening and building relationships and gaining trust among states, but also the non-governmental community in terms of having today the agreement that we have, that we are very proud of it in terms of its what it has achieved in terms of environmental governance here in Latin America and the Caribbean. So I will start with the building process of the Escazú Agreement, and then Maria Antonia will go through the content of the agreement. That will be the main part of this presentation, because the agreement is very interesting in terms of all its legal aspects and all the specificities of the three aspects of the access rights, but also in terms of the building block of cooperation among countries. And then Daniel will proceed with implementation, which is also the next step, and which is also the main responsibility now that the agreement entered into force. So let me refer in this first part of the city, of the class. I'm sorry, I will try to be strict with the time that was assigned to me. I will refer to the building of the Escazú Agreement. And the Escazú Agreement, of course, has its roots in Principle 10 of Rio Declaration. Of course, in 1992, one of the main of the foundational principles of the Rio Declaration that was also translated and incorporated, I should say, in most of our countries here in Latin America and the Caribbean, as it happened, of course, in other countries of the world. But the main, the objective, the idea behind the Principle 10 was translated in many legal frameworks in Latin America and the Caribbean, but of course not a legal, not a multilateral instrument as the one that the region of Europe was able to achieve last century in 1990 through the Aarhus Convention. The Latin American and Caribbean region is not particularly active in terms of regional environmental multilateralism, and this is also one of the aspects that make the Escazú Agreement a landmark. It is the first regional environmental agreement. But until 2012, countries agreed within the framework of the Governing Council of UNEP, and as an intergovernmentally achieved result, the Bali Guidelines on access to information, public participation, and access to justice in environmental matters. Those guidelines were adopted by the Governing Council in UNEP. They are universal, but they are not legally binding. They provide direction and orientations, and I should say also that they were, and they are still, of course, very important in terms also of the Escazú Agreement process, because the Escazú Agreement, the initial discussions of the Escazú Agreement were built around the discussion on what the region have achieved in terms of the Bali Guidelines, and what were the gaps in terms of achieving all the purposes and aims of the Bali Guidelines of on access to information, public participation, and access to justice. In 2012, you may remember that the Conference on Environment and Development and Sustainable Development took place again in Rio de Janeiro after 20 years of the declaration of Rio. And that meeting, you may remember that was not, it was very important in terms of the discussions, in terms of strengthening of environmental governance in general, in terms of the future we want, the document that was the main outcome of the conference, but of course not legal instruments coming up from that conference if we take into reference what happened 20 years ago in the same city of Rio de Janeiro. But one important regional achievement in Rio +20 was that at that moment, 10 countries of Latin America and the Caribbean signed a declaration aiming to start, not a process, even the word process was not there, to start a regional discussion, a regional dialogue with regard to the to the strengthening of actions or collective actions or joint actions towards the full implementation of Principle 10 of the Rio Declaration in Latin America and the Caribbean. So that was the starting point. That was the birth date, I should say, of the process of negotiation and consolidation of the agreement. At that time, as I said, the word process was not mentioned, and not, of course, not the word agreement. It was not even decided how these conversations or this initiative will achieve. And between 2012 and 2014, a preparatory phase took place. And there we have, as I mentioned, we have work in terms of preparing the conceptual basis for starting to think about a regional Latin American and Caribbean perspective on Principle 10 implementation here in the region. And in that regard, again, I should mention that the Bali guidelines, that internationally agreed commitment in order to that provides direction to countries to implement Principle 10 were very important, and they were taken into account in order to see which was at that line the baseline for countries in the region to start to think what else or how far they could advance, and what were the gaps at that time that, of course, some of them already persist, in terms to start looking not only in terms of having a document, having an agreement, having a declaration, but also to start to see what we need for implementation of the commitments already achieved, or the commitments that countries may be willing to engage in through this regional initiative. So by that time, then a process of the agreement, a process of negotiation of the agreement started under the framework of the ECLAC, the Economic Commission for Latin America and the Caribbean. And it was a process that never ceased in gaining ambition, and also in attracting more countries of the region until its adoption on the 4th of May of 2018, as I said, in the city of Escazú in Costa Rica. Negotiation meetings were conducted by a committee composed by countries, but one very important aspect that I would like to mention at this time, and that has a substantive impact in terms of the ambition that I was mentioned of what the Escazú Agreement already says at this time, is the participation of the public. A public mechanism, it was called in that way, mecanismo público, en español, public mechanism, was created as a platform for participation of stakeholders, NGOs, citizens from the region, organizations, institutions that contribute in a very, very active way in the different stages of the negotiation of the agreement. And this public mechanism still has two representatives, one from Latin America and the Caribbean, one from Latin American countries and one from the Caribbean countries, who represented the public mechanism in the negotiation meetings. And they, as I say, they contributed substantially to the provisions of the agreement and to the, in particular, in aspects that are very important for stakeholders and citizens in the region, as, for example, environmental human rights defenders, these important provisions that we find in Article 10 of the Escazú Agreement. So we have different documents along this process that were, as I said, were building blocks towards the final text of the agreement, and that provide a conceptual and substantive basis for the content of the agreement today. That process, the negotiation process, concluded in 2018. The 4th of May, the agreement was adopted in Escazú, and then we entered at that moment the process for its adoption. I'm sorry, for its signature and ratification by countries. The agreement needed the adoption by 11 countries, 1/3 of the countries of the region, for its entry into force, and it enters effectively into force in 2021. On the 2 months ago, on the 22nd of April, the Day of Mother Earth, with the ratification of 12 countries and the signature. There are 24 countries of the regions that have already signed the agreement, and 12 countries that are part of the agreement, which entered into force on the 22nd of April. Here you can see the countries that have that are part of the agreement and the countries that have signed the agreement. And what I would like to visualize, the first one was Guyana in 2019, and the last country which who allowed the entry into force of the agreement was Mexico in January 2021. What I want to convey to you at this is a message that here that you may see a very balanced participation of Latin American and Caribbean countries. And when I refer to the process, I should have also said that the process started as mainly a Latin American gathering of countries, countries from Latin America. But then the Caribbean was starting to participate more in a more active way. And as you may see, it was a Caribbean country who allowed the entry into force of the agreement, who started the ratification of the agreements, and we have a very balanced participation of countries that are small islands, small developing states islands, and countries of Latin America and the Caribbean as well, and countries as complex and big as Mexico, with all the challenges that represents implementation of multilateral agreement in Mexico on these specific areas. So with this, I think I will pass to Maria Antonia. This slide represents the status of the agreement, and I would say here that paradoxically, the two countries that were the main leaders in terms of moving forward the negotiations of the agreement, and Chile and Costa Rica are not still parties of the agreement, and other countries as well that participated very actively in the process, like Peru and Colombia. Actually, in Colombia, there was a parliamentarian debate on the Escazú Agreement in last week, and we were all willing that the Escazú Agreement can also be adopted in Colombia as well. But this also may allow us a reflection in terms of the ambition of the agreement vis-a-vis the challenges that countries of our region face in terms of achieving its objectives, and the many social complexities of the region, and how difficult it was, and how challenging and therefore how rewarding it is to having achieved an agreement of this type in Latin America and the Caribbean. So this is not a photo. This is a film, and we expect, and we are supporting, of course, countries, and we expect to have more countries on board, more countries that can be full parties of the Escazú Agreement very soon, before the conference, the first conference of the parties of the agreement meet. And with this now, I think that I will not extend more because my time is out. Thank you very much for the attention, and let us listen to the context of the agreement and what does the agreement say, why it is very important from Maria Antonia. Thank you very much.
Thank you, Andrea. Thank you for this introduction. It's such an interesting, it's interesting to hear about the process too, because it's also, it embodies really the access rights and the public participation and all of that from how the agreement developed too. So I'll try to talk a little bit about the content. It's obviously very difficult to talk about all the interesting aspects in such a short amount of time, but I'll do my best to give sort of an overview of what it covers. So first, just talking a little bit in terms of the importance of this, and we're obviously in this growing age of this emancipatory environmental politics, right? It's been recognized at a widespread level how environmental issues are really best handled with the participation of all concerned citizens because of all the complications of environmental decision making. So the diversity of interest, the plurality of the values that are involved, and the uncertain nature of environmental knowledge as well, which is always changing. And the risk as well. It's so complex that it's best if we have participation from different stakeholders. So really, Escazú is deeply committed to this, obviously, to the pursuit of justice, and provides this bright vision of environmental democracy. And it joins the Aarhus Convention in establishing and implementing access rights. But the interesting thing is that it takes the same values from Principle 10 and from the Aarhus Convention, but it really gives a regional spin to it. And it really recognizes the specific challenges that we face in Latin America and the Caribbean. So Escazú is really it's a binding treaty, and it's an environmental treaty, but it's also a human rights instrument, and that's explicit in the beginning of the treaty. It expresses this nature, this double nature as a human rights and an environmental treaty. And the importance of that in terms of practical implications, maybe we'll talk a little bit more about this with Danielle, is that it can be invoked between the human rights protection system of the Organization of American States. So that's really a very important implementation aspect of the treaty itself. So in terms of the preamble, I think another important thing to mention is how it acknowledges how the access rights are interrelated and interdependent, and the implementation shall be integrated and balanced. And so it underlines this interdependence between human rights and the environment, right? So that's obviously what we're talking about here at the summer winter school, and it's at the core of what GNHRE does. So it's particularly significant, and it also acknowledges the multiculturalism of Latin America and the Caribbean and their people, and the importance of environmental defenders. So I think most of the times when people talk about Escazú, they really highlight this aspect of environmental defenders, which was really very unique, because it was really the first treaty that recognized that aspect of protection as well. So I'll talk a little bit first about the right to a healthy environment, which is the substantive environmental rights, which is acknowledged by the treaty. So it's acknowledged twice in Article 1 and Article 4, first as the goal of the treaty, and it includes contributing to the protection of the right of every person or present and future generations to live in a healthy environment and to sustainable development. So it talks about both present and future generations. So this intergenerational aspect is really important. And it also aligns with the 2030 Sustainable Development Agenda and this commitment to leave no one behind. And in Article 4, it really asks each party to guarantee the right of every person to live in a healthy environment. and other universally recognized human rights related to the agreement. So it talks about specifically the substantive right to a healthy environment, but also this relationship with other human rights that are recognized. And in addition to that, there's also an obligation of each state to ensure that the rights defined in the agreement are freely exercised. So it provides for the adoption of legislative, regulatory, administrative, and other measures to ensure the implementation of the agreement. And that's very significant because Latin America and the Caribbean it's a region that has adopted the right to a healthy environment really widespread, but obviously not each country has adopted it. So it's significant in that it also expands this substantive right to a healthy environment to other countries that may not have recognized it in their constitutions yet. So, and in addition, the recognition of this substantive right is really essential, as the procedural rights provide a means to protect the substantive rights. So there's obviously a relationship with that as well. So the parties really recognize that the rights contribute to, and the access right contribute to ensuring the substantive right, but are also not sufficient to guarantee it. So there's this double aspect as well. So I'll talk a little bit about the principles then, because it's, I think it's important to, obviously there are lots of them, so I won't go into details, but I wanted to highlight a couple that are pretty unique. So the principle of non-regression and progressive realization, it's relatively new in international environmental laws. It's the first time that it was recognized in a binding environmental agreement. It obviously comes from human rights law, which is already has adopted it more significantly, but it's very significant that it was adopted there as well. And the other principle that I wanted to mention is the principle of pro persona, which is also extrapolated from regional human rights law from the inter-American system. And it calls on human rights standards to be interpreted in a way that is most favorable to the human person and protects human dignity. So it creates better guarantees for the rights of victims of human rights violations, and obviously bringing that into an environmental perspective too. So I think we'll probably, hear more about this once the agreement is implemented, but I think it's a particularly significant aspect of it. So the agreement really focuses on the three traditional pillars of access rights. So the right to access information, the right to participation in decision-making, and the right to access to justice in environmental matters. But it also brings additional pillars. So the rights of environmental human rights defenders, and this aspect of capacity building and cooperation, which is very important for the implementation of the agreement itself. So I'll start by talking a little bit about access to information as an initial point of reference in any type of public participation. So there are two aspects of it. There's an active and a passive aspect of access to information. The passive one, it's when each party really undertakes to ensure the public's right of access to information in its possession, control, or custody. So the agreement establishes particular criteria on the rights to request and receive information, such as the public does not need to mention any specific interest or explain the reasons for the request. They can challenge and appeal the non-delivery of information. The information should be timely and be delivered within 30 business days. There's a small exception to it, but it can't be extended much. And if it's extended, it has to be informed and explained. Also has to be the cost provided at no cost, or at a reasonable cost that's also informed in advance. And there's a particular aspect related to vulnerable populations in terms of how parties shall ensure that there easier access and procedures that they're easier for them to request the information. And information should be functional, accurate, and comprehensive, yeah. So, and in terms of the active aspect of it, the agreement requires each party to guarantee that environmental information is generated, collected, publicized, and disseminated in a systematic, proactive, timely, regular, accessible, and comprehensive manner. So parties must take steps to establish environmental information systems and pollutant release and transfer registers. So it specifically talks about some of those systems and encourage independent environmental performance reviews. And each party shall also guarantee that when there's an imminent threat to public health or the environment, that relevant competent authorities shall immediately disclose and disseminate information so that measures could be implemented to prevent or limit potential damage. And early warning systems should also be developed and implemented. And the other interesting aspect is that it ensures that there's a progressive implementation of access to information in electronic databases as well. So Escazú establishes that the specifics of a report that should be published, and the possibility also that the public contributes to that report. I think it's a pretty interesting aspect. So in terms generally, Latin America and the Caribbean, a lot of the countries have already enshrined the access to public information in the constitutions, either through recognition of freedom of expression or through habeas data provisions. And most countries also have specific laws or are in the process of passing or drafting such laws. And there are also numerous national courts in the region, in addition to the Inter-American Court of Human Rights, that have already recognized access to information as a fundamental and universal right. And in addition to the right itself, a lot of laws in the region have also provided for mechanisms to facilitate such access. So as an example, Antigua and Bermuda has a Freedom of Information Act in which public authorities must appoint information officers to act as a specific contact with the public. There's Brazil and Argentina have specifically enacted laws for systems of access to environmental information, which is also particularly unique and hopefully sort of a good practice that could be replicated in other countries too. So moving on to public participation, the Escazú Agreement provides for public participation in environmental decision-making via mechanisms to participate in the process to issue authorizations and revisions of projects and activities that have or may have a significant impact on the environment. So there's a broad scope on the content of the agreement, and the conditions need to be adapted to the socioeconomic, cultural, geographic, and gender characteristics of the public. And parties should also ensure that there are proper spaces for consultation that ensure diversity of groups and sectors, and value local knowledge, dialogue, and interactions of different views and knowledges. So I think I'll talk a little bit more about this later, but you can see that throughout the agreement, there's always this recognition of different values, different groups that may be a part of it, so vulnerable communities, sometimes specifically indigenous communities. And so public participation in other decision-making processes, such as plans, policies, strategies, rules, and regulations shall also be promoted. And in both cases, it shall take place from an early stage and contemplate reasonable timeframes so that there can actually be due consideration to the observations of the public. And information should be clear, timely, comprehensive, and provided through appropriate means. And public authorities shall make efforts to specifically identify the public that's directly affected by projects or activities that may have significant impact on the environment and promote specific actions to facilitate their implementation. Also, when the primary language of the affected public is different from the official language, the public authority shall ensure that means are provided to facilitate their understanding and participation. So similarly to access to information, most of the countries have already included public participation provisions in their environmental legislation, sometimes have been given constitutional status, and there's particular mechanisms that have been established for that, sometimes through a semi-direct or direct democracy mechanism, such as popular legislative initiatives, which can obviously serve environmental purposes, and most have created formal consultational arrangements for environmental affairs, which call for contributions from different sectors of society. And there's also the legal recognition of peaceful assembly and association, which is particularly important to really ensure that there's participation from a wide range of stakeholders here. And then access to justice. Each party shall ensure the access to judicial and administrative mechanisms to challenge and appeal any decision, action, or omission related to access to environmental information or public participation, as well as any decision, action, or omission that affects or could affect the environment adversely or violate laws and regulation related to the environment. So there's this particular aspect of decision that could affect the environment can be considered sort of a fourth pillar as a new right, because it guarantees the external review and strengthens the role of citizens and NGOs in the implementation of the laws, as well as ensuring other challenges that sometimes people face, such as when international treaties are not internalized in national law. So this specific provision provides an avenue to address this, and it clarifies that the public also has a role in applying the law through a duty to conserve and protect the environment for present and future generations. So I think that's a really significant aspect of the agreement. And considering the circumstances, each party is required to have competent entities with expertise in environmental matters, have effective, timely, public, transparent, and impartial procedures that are not prohibitively expensive, broad active legal standing in defense of the environment, and mechanisms to facilitate production of evidence and redress. So that's also very significant for environmental damage, because the burden of proof is reversed. So it follows the laws of several countries in the region that have already established this reverse burden of proof, or a dynamic burden of proof as well. So again, most countries have already given constitutional status to measures for exercising the right to justice, either through constitutional or legislative advancements in that regard, and specifically also including sort of a legal formula to initiate legal proceedings in defense of diffuse interests or the environment itself. And in terms of some examples for procedural remedies and specialized courts, Trinidad and Tobago has set a court specializing in environmental matters. There are also countries in the region that have also established something similar. And that's very relevant because it has judges that are trained in environmental matters, or engineering, natural sciences, or social sciences. It's obviously very particular to what the specific issues may be. And another very significant aspect is really how several countries have established human rights institutions or ombudspersons. So public institutions, usually of constitutional rank, whose main purpose is to promote fundamental rights of the country's inhabitants. So they're usually independent of the executive, legislature, and judiciary. So it really provides a link between individuals and the governments, and provides a very useful role in access to environmental justice. And finally, the guarantees of due process, which is also a very important aspect of access to justice. So it requires each party to really look at their normative framework to ensure that that each element is adapted to the social, historic, economic, and geographic and environmental circumstances of the particular country, and really have environmental bodies that are grounded in environmental matters. So the access to justice here is really broader than what was established in the Aarhus Convention, for example, because in Aarhus it was limited to violations of rights directly related to the subject of the agreement. But in Escazú, it guarantees access to justice for like the denial of information as well, or the inability to participate in decision-making processes or other decisions that could affect the environment. So that's very, very significant in that. So finally, I wanted to mention this aspect of persons or groups in vulnerable situations. I mentioned this a little bit throughout the 3 pillars, but it really, Escazú really provides a lot of attention to groups in vulnerable situation throughout the agreement. And really, the idea really is to place equality at the core of sustainable development. So it is deeply committed to unravel inequalities. So that's one of the aspects that I mentioned of sort of the regional peculiarities of the agreement that were adapted here in terms of implementing Principle 10. So in access to information, access to justice, it really, it's really throughout the agreement, and to meet the needs of each person and provide assistance to actually allow them to participate. And another curiosity is that in the previous draft of the agreement, they included the principle of in dubio pro natura, which is a little different from the precautionary principle, because it applies this uncertainty when balancing not only the scientific aspects, which are unclear, but also specific norms or fundamental rights, and it would be, any decision would be in favor of nature, and that was unfortunately excluded here, but that would also provide a more environmental protection in that regard. And finally, in terms of the indigenous peoples, there are 2 articles that specifically mention them. And Escazú has been criticized for not really explicitly exploring other important issues related to indigenous peoples and incorporating some other norms, international norms here. But obviously the aspects that mention vulnerable populations also include them as well. So in terms of environmental defenders, I think I think we'll talk a little bit more about this with Daniel and in terms of the implementation, but the threats to environmental defenders, it's really a significant challenge that people face in Latin America. If you can see this chart from Global Witness, you can see how a lot of the countries that are ranked higher in terms of killings of environmental defenders are based in Latin America. There's really been a rise in land and environmental conflicts since like 2010, and there's really no exception in terms of the countries that, like most countries in almost all countries in Latin America and the Caribbean are included among those lists in terms of how many environmental conflicts exist. And obviously not only killings, but threatening, and there are also other violations of their freedoms, such as censorship, harassment, intimidation, use of excessive force. There's a lot that they faced, and Escazú is really specific in actually trying to protect them from those threats to ensure that access rights are exercised, right? So the protection of environmental defenders in the agreement is really one of the objectives of the agreement, to transform socio-ecological conflicts and prevent them from turning violent, protect environmental activists from intimidation and hostility, as much as threats to life and to live as well. So it's the first legal agreement in the world to stipulate procedural safeguards to protect environmental activists who campaign for the preservation of natural resources, and it really requires parties to guarantee a safe and enabling environment for anyone who is defending human rights in environmental manners, and take effective measures to recognize, protect, and promote all their rights, and prevent, investigate, and punish any attacks, threats, or intimidation they suffer while exercising their rights. So, because that's another important aspect of it, is not only preventing any of those threats, but actually doing something once that happens, which also rarely exists, really. So then the sort of the fifth pillar would be this aspect of capacity building and cooperation, which is very significant because it provides how the rights shall be applied under the agreement. So Article 4 actually mentioned that the agreement is a floor, not a ceiling. So it really provides the basic of what should be offered, and ensuring capacity building and cooperation really is a way to expand on that. So the three access rights supported in Escazú, the rights are supported by these aspects of capacity building and cooperation, which include training of authorities and civil servants, capacity building programs, provision of adequate equipment and resources, promotion of education and public awareness. There's also a clearinghouse that has been foreseen, and the agreement provides for a voluntary fund to support the financing of its implementation, and a committee to support implementation and compliance to meet the obligations of the treaty. And really cooperation sort of at the core of what the agreement envisions. So it cannot, this cooperation is between states and citizens, but also between states themselves in terms of implementing it. So there's really a multilateral nature here, because it adds these vertical obligations to existing national obligations, and promotes cooperation and capacity building of the least advanced countries in the field as well. The last thing I wanted to mention is, from a business perspective, there's also a significant obligation here in terms of implementing the rights protected here, because obviously public and private companies, large companies are required to draw up sustainability reports, to disclose their social and ecological record, provide more transparency in terms of any information on projects and all of that. And the Aarhus Convention had provisions that protected commercial secrets and intellectual property, and that doesn't exist in Escazú. So there's an obligation here to take all measures to promote access rights differently from what the Aarhus Convention had done. So I'll move on to Daniel, and I'm available to answer any questions that you may have.
Thank you, Mar Antonia, and hello to everyone. Sorry I was late a little bit at the beginning, but we are in the period of sessions of the Inter-American Commission on Human Rights, and I was just in a meeting regarding a precautionary measure, therefore my tardiness, which I apologize. So we can go to the next slide, please. Well, beyond the elements that I think already Mar Antonia explained widely about how the agreement compels and how the agreement forces a lot of mechanisms that were already thought about in previous environmental conference and were basically established under Principle 10 of the Rio Declaration, and we went amply about what are the rights that secure them. However, my part of this presentation is going to focus on how is the implementation of the agreement being applied at this moment in among the various parties that have ratified it. And we're also going to observe some of the challenges towards the effective implementation of this agreement. And I think that the main concept here that arises is that we have to vision the at least in my view, I see that the vision of this of the agreement is in itself a tool as it was an end. I mean, when the negotiations that lead, as Andrea explained it at the beginning, came obviously from a series of conversations that began before, since 1990, and especially with a predominant role of the civil society to actually push for an environmental agreement of this kind within this region. Although there has been provisions for these type of situations under the regional human rights regime, however, we actually needed like these specific set of rules regarding environmental law and human rights law that amply that basically stated the main obligations and what will be the next steps in this matter. So first, we're going to see what are the benefits in regards to the implementation, how some states are already trying, even before the implementation of the agreement, are trying to accommodate their framework or the institutional framework to comply with the obligations set out in the agreement, what can be done or what can also be done in other spaces to secure these compliances. Some of the good practices that we're gonna see into, I basically pointed them out as other as some practices that are already implemented, even though like even some of these parties have not even ratified as of this moment the agreement. However, I think it's responsible to say that even though they have these institutions that will tackle some aspect of the agreement, it's important to reiterate the character that the agreement has to properly secure the access rights in regards to environmental matters. So I think that when we're gonna look into like the implications of certain parts of the provision and the institutional framework, that although these states have that institutions placed, but are not part of the agreement or have not already ratified it, although they have signed it, I think it's important to clarify that even though they have the institution placed or they have some sort of institution that responds to the obligation, I think it's important to state that they still need to ratify the convention. They still need to, at some point, become part of the institution to properly tackle and to properly, in good faith, secure the effective implementation of the agreement. And then we're going to see some challenges that we're facing, especially as Maria Antonia Curie pointed out in her part of the presentation, the situation of human rights defenders in the Americas is worrying. Not only we're talking about, I mean, the agreement is focused mainly on Latin America and the Caribbean, but I think it's valid to say that the situation of environmental defenders in the entire region of the Americas, that means from Canada to Patagonia, is dire. Coming from the Inter-American Commission on Human Rights, from the Special Rapporteur on Economic, Social, Cultural, and Environmental Rights, we have been perceiving a pattern of different types of systemic attacks against environmental defenders in many countries. And one of the main examples that we can see on the dire situation of environmental defenders, of course, is the case of Berta Cáceres, which is right now being processed in national courts in Honduras, and as well the one part of the reasons that moved the social mobilization in Colombia have been as well almost the daily killing of social leaders and environmental leaders in the country. So I think it's important to understand the context of what does the treaty want to aim towards, and what is the current reality and what are the challenges that we're facing. So can we go to the next slide, please? Perfect. So in terms of benefits and why it's important that the countries ratify and be part of the agreement mainly. So first, that the access rights are guaranteed as an international norm. And why is this important? Because the ample scope of obligations from the state in relation to access rights beyond being established in other norms that relate to access to information, we have a specific set of obligations in terms of environmental matters. In the Inter-American framework, we have various norms and case law, especially from the Inter-American Commission, from the Inter-American Court, sorry, that have stated what are the aspects that states should ensure in relation to access to information, especially in environmental matters. An early example on how, for instance, the Inter-American system dialogued with this right was in the case of Claude Reyes versus Chile, when there was when the decision of the Inter-American Court was actually to declare the international responsibility of Chile for denying access to information in an environmental sensitive project to a person. So we have already the framework, but it is important that this new set of norms are specific to environmental matters. There is also like this tendency that's coming, as it's called, that is a youth constitutionalism that is common towards the whole region, that also impulses and pushes towards a conception of access rights that is common and can see as also an international legal norm from a customary point of view. Second, we know that there are specific obligations towards the protection of environmental defenders. Maria Antonia explained amply about what does it mean. And I think it's important that there is a specific obligation towards environmental defenders, especially in the context that we are living. We're still right now the most dangerous region to be an environmental defender. And personally, I don't think there is like a way right now that countries are effectively responding to this responsibility, and that is, I think, is why it's so important and it's so crucial that the agreement has these specific obligations towards environmental defenders due to the context that we're living. And finally, it's complementary with other inter-American norms. Although the agreement does not emanate from the Inter-American system, meaning doesn't come from the OAS or other bodies that come from the Inter-American system, it's still a regional instrument that comes from a universal body, which is the ECLAC or CEPAL in Spanish, but has its effects in the region. In that sense, what we have seen is that it's complementary to other inter-American norms. And here I would like to call into attention Article 29 of the American Convention. And why is that article important? Because that article especially states that any interpretation of any norm that emanates from the inter-American system, it doesn't have to be restrictive to the implementation of other rights. In that sense, I think what the agreement comes to do is to actually see and make it more robust the inter-American framework that actually exists at the moment, that in some part it protects. With this brief introduction to its main benefits, I'm gonna just set out some good practices that I have identified, as I said earlier, that have been done by certain countries that to some point respond to the obligations that the agreement sets out. However, as I said earlier, some of the countries that I have listed, some of them are not are not part as of this moment of the agreement. However, it is important to just like light out, to point out these special practices, but also reiterating that it's important for these countries still to ratify the agreement and to be part of the agreement. This is a call that the Inter-American system has set. We even, from Redesca, we issued a press release in August of last year with the Special Rapporteur for Human Rights and the Environment, calling actually for the ratification of the Escazú Agreement. And we also like published a press release when the Escazú Agreement entered into force this year, also stating the importance and the complementarity of the system, and also calling again for the massive ratification and universalization of the treaty. The second point that I would say that is another, and also, sorry, given this development of institutional framework that I was talking first, what we mean is basically that the state has created sufficient institutions to appropriately tackle or address any point or specific points or obligations that emanate from the agreement. In this sense, what we have seen is that there is a creation or a proliferation, and this was especially since the 1990s, since the decade of the 90s, primarily with the adoption of the model law of access to information that emanated as well from the Inter-American system in general. And what we have is a proliferation of access to information institutions. So there are institutions in various countries, especially, as I said, Mexico, Colombia, and Uruguay, that are dedicated exclusively to secure that the public has access to information. We have seen that this is important. In this case, for example, Colombia is not part of it has signed the Escazú Agreement, but has not yet ratified. Well, I'm gonna go into that a little bit more further on. But it's important that there is like an institution that secures an effective access to information. In this sense, what we have seen as well is what important role human rights institutions have. Either be a commissioner, a national commission of human rights, an ombudsperson, an institute that is only dedicated to the protection of human rights within the country, but their role in securing any of the parts of the rights contemplated in the agreement, it's crucial for its effective implementation. We have not seen any human rights institution at the moment to appropriately to appropriate any oversight of the any oversight of the implementation of the agreement, but their role in general, especially given the context of the region, I think it's important to take into account. Second is the involvement of civil society, and I think Andrea and Maria Antonia have stated clearly how civil society, especially their involvement in the construction of the agreement, and then how the agreement itself has put in the center of action civil society. It's also an important part. In this line, we need to see that there is an effective public participation in various decision-making processes. This goes from environmental permits, we can go into even zoning and zoning laws in cities, even in the planning of development of countries, meaning like if a country decides to implement a model of economic development, of economic regrowth, for example, in the context of the pandemic, that the public is present in those parts, and that is one of the important parts that the agreement has specifically set out. What we have seen, especially, and again, I'm saying that these are just examples that can be implemented in countries that have already ratified, especially here in the United States, citizen organizations have been vital in putting at the forefront of the discussion climate issues, environmental issues in decision-making processes in different aspects. And in Honduras. In Honduras, the citizens have been the ones who have been more present in trying to set out different strategies again to secure the access to information or to participation in environmental matters. And what is interesting in Honduras is that we have seen an articulation between the public and the human rights institution. The Human Rights Institution of Honduras is the National Commissioner of Human Rights, and both the National Commissioner with various citizen organizations have tried actually to set up different forums, trying to do some sort of lobbying, I would say, although I don't think that's the most appropriate word, but try to compel different actors to actually hear the public and hear the public's concerns in different aspects. Citizens organizations, in my view, have the, and when I mean citizen organizations, I mean mainly grassroots organizations or community organizations. We're talking about organizations that come from affected communities directly. I mean communities that have been directly affected by any type of project or who are being displaced, for example. And these are the ones that need to have more voices in this type of processes. And finally, there needs to be ample opportunities to secure the judicial review, and this also comes in line with the pillar of access to justice of the treaty, and this also goes in line with the measures that the states have to take to secure the protection of environmental and land defenders. And environmental, land, and nature defenders, I will put out, because that's how we try to call them in Redes especially. So beyond the ample opportunity to do judicial review, what are like some good practices or what can be some institutional decisions that can be made to secure these rights? So one of the main points that have been always discussed in environmental governance, especially, is obviously to create a specialized courts in environmental matters. We have the cases of Chile and Costa Rica who have environmental courts. However, especially in Chile, they are more from an administrative law point of view. But this is one mechanism. There has been discussions that within the framework of these environmental courts, some cases in relation to constitutional rights can be heard, especially, for example, cases related to environmental defenders be heard before these courts because it's in this specific context. There has been proposals to reform the environmental courts in Costa Rica, again, to actually hear these type of cases. And in line with this, there is also a call to call for specialist prosecutors or other type of public officials that can have some sort of power or interest on following these specific cases. And we have a network in Latin America of environmental public prosecutors, especially, and we have to see until what point can these prosecutors can actually be effective, especially in protecting the environmental defenders, especially. In this case, talking about possible chances of what people can be, or how can people, for example, these prosecutors protect environmental defenders. And I'm not so sure if there is like a definite answer yet. This especially comes in times because what I've seen or what we have seen as a monitoring in general from the commission, and this you can look up in our annual report of 2020, is that there is a lack of will from the institutions of how they can articulate security measures for these environmental defenders. It's a case by case basis, most of them, but still there needs to be more. I will say there needs to be more decision, a stronger decision from the states to properly come in terms with these aspects. Can we go to the next slide, please? Sorry, Natalia. Thank you. Therefore, so we have seen, I have talked like in brief about like these good practices that have come along. However, there is a harsh reality that we have seen. So what is the present reality of the situation, and what's the gap basically between the real implementation and what the agreement proposes, or what the agreement looks for? First, it's just that I cannot stress this enough. It is still the most dangerous region to be an environmental defender, according to Global Witness report of 2019 that Maria Antonia stated before. But again, from the Commission, we have seen that these acts are still happening. Just in this year, there has been murders of environmental defenders in Ecuador, Mexico, Peru. We have identified acts of, or we have identified acts of persecution or intimidations against defenders in a lot of countries of Central America. And well, I mean, the situation in Colombia, of course, it's more complex at this moment. But again, as I repeated earlier, a part of the social distress also comes from the inability of the state to actually propose a comprehensive policy to support especially social leaders in the rural parts of Colombia. And we have not seen at the moment any type of even creating a proper comprehensive policy. And what is also very, very worrying is that the tools are there. I mean, the tools are there beyond the Escazú Agreement. The Escazú Agreement gives them a specific obligation on this matter, and it creates more ample obligations beyond the implementation committee that has to be set up by the conference of the party to see how the Escazú Agreement will be implemented. There are still more tools within the framework of the Inter-American system, the universal system of human rights, but we have to see how states will wish to address the situation. And we're still seeing the further criminalization of environmental defenders. And adjacent to this, we're still facing challenges to access to information and participation in environmental matters. During the pandemic, for example, what it was worrying is that there was no preparation from especially environmental institutions when it comes, for example, to create mechanisms to access public consultations. In certain countries, they were issuing or trying to issue moratoriums in giving out permissions to continue certain industrial activities, but those moratoriums were just for a couple of months, and then the permits and those processes of allowing environmental impact assessments to continue moved on. However, a lot of those processes lacked effective public participation. Some countries, for instance, try to create these spaces for public participation through technology mechanisms like video conference and such. But civil society organizations said that due to the digital breach in the region, it was impossible for example, rural communities to access these meetings, for example. So those are challenges that we're still facing. We're still facing that there is no basically the transformation of specialized environmental judiciaries in more countries. For instance, in Ecuador, I'm from Ecuador, so that's why I'm more familiar to the issue. Ecuador has a constitutional mandate to have a specialized environmental judiciary. It has not complied with that mandate until now, and until now there has been no direct order from that. We have not seen any other countries that would like to do it. But I mean, there is still a discussion on how these other points will be implemented. But from a standpoint of the monitoring side of what is the situation on those pillars, it's dire. It's dire, and it's worrying to see what will what willingness will governments have to effectively implement the agreement. And this is why I'm going to my final point, which is the political environment. And I would like to stop this like for my, I think I have like 2-3 minutes before I end. Why is this is important? Because we have seen in certain countries that the political debate is not going forward. Especially is worrying when the countries that actually promoted this agreement, that were behind the negotiation, I'm talking specifically about Costa Rica and Chile, are not the ones who have not moved on for the ratification. And it's worrying that there is like an agreement between certain sectors of the society with certain political actors, especially in the legislative bodies, that have in some way distorted the message. And we have seen especially this in Colombia. In Colombia, this last weekend, the ratification of the agreement was put in the debate of the Senate, and it didn't move on. It got archived in the Senate, and the process didn't move on. This has happened also in Chile. This has happened also in Costa Rica, and we cannot see what will be the future. This is mainly due because first there is a vast disparity in like the lobbying tools. And what do I mean by this? Basically, the mechanisms of influence that certain actors may have against others is very dissimilar. If you we're seeing here basically human rights institutions or human rights organizations and rural communities against conglomerates, against chambers of commerce, and against other economic actors, especially who have an special interest, that these tools that promote more ample participation and secure access rights in environmental issues cannot be applied by the state. And just to begin closing, of course, most of the content of the agreement is already part of the content of the Inter-American system. And I think that is important to clear out. However, the obligations that are pointed out in the agreement are very specific. They are more in detail of what each of those elements are. And also it complements what the Inter-American Court of Human Rights already stated in their advisory opinion 2023 of 2017 that set out the various elements that compose the right to a healthy environment within the Inter-American framework. So it dialogues very much with it. But this agreement does provide with more detail those obligations. And it does not create additional jurisdictional flaws, or doesn't create additional competencies to regional bodies like the Inter-American Human Rights Commission or the Inter-American Court. Even though countries do not ratify the Escazú Agreement, some of the rights that are there can still be observed by the Inter-American system. But it is important to point out that it is better if the countries ratify the agreement, because it also shows a good faith sign that they are willingly wanting to increase the responsibility and increase the protection on certain points. So I will close that there. I think I am just in my time. If not, Natalia, please, or somebody else, let me know. But I'm here for your questions. And basically, next steps. For next steps, there are a couple of things. We first need to see the next conference of the party, which has to be 1 year since the ratification of the agreement. In the conference of the party, we'll see how the implementation committee will be organized. We will see how certain decisions will be made in that context. But I will leave it there, and will let my my colleagues also talk about some of these issues. Thank you very much.
Thank you. And thank you, all three of you, for this great and comprehensive presentation. It was truly inspiring to hear from you discussing the importance as well as the challenges of this groundbreaking regional agreement. So we do have a couple of questions that I would like to pose. I think I'm gonna stop sharing the screen. So yeah, the first question that we have from the audience comes from Maria Paula Gonzalez, and she asks, what particular participation mechanism do you think countries may implement to comply with the agreement? I think maybe Maria Antonia, you could start with this one, and if Andrea or Daniel wants to chime in, that's also fine.
I think there are several examples throughout Latin America of sort of good practices that have already been implemented and that could be replicated in other countries. It depends a little bit on which aspect we're talking about, but like ensuring that we have environmental courts, ensuring that we have a legislation that provides for access to information and public participation in all stages of decision-making process in environmental matters. I think I mentioned a couple of those throughout my presentation, but I think what's interesting about this is that it sort of brings all of the countries together to think about those issues and actually hopefully share information. That's why this aspect, this fourth pillar of cooperation and capacity building is important, because it could really, countries could rely on one another to actually bring together similar experiences and really facilitate replicating those mechanisms in other regions as well. So maybe Danielle and Andrea have some other examples that I haven't mentioned here that are worth noting as well.
If I may, yes?
Please do.
If I may, I would not mention specific examples, but I would say that this is, I mean, the agreement mark or orient and establish a standard, right? Not the minimum elements that the participation and public mechanisms should have. And I think that this will depend very much on the different situation of the countries. We have, the region is very heterogeneous, right? We have big countries with challenges in terms of multiculturalism and with challenges in terms of languages. We have small island states development. So it will depend very much on the reality, the legal, but the reality in the ground of the country. And this is also why it is very important that even the agreement itself has a pillar on cooperation, so countries can share their best practices, their experience, can learn from each other. So I think this is not that one size fits all in any case, because public participation, I think, is one of the most challenging issues with regarding to environmental management. And if I may, I think that we will never be there, no, where we want to be in terms of public participation. It is something that we continuously need to move forward, and we will not reach in any case a stage of a perfect state in which we can say, okay, all people in all the country in different ways are able to participate in all relations, in all decisions that relates to the environment. No, so it is an aspiration. It is a legal community commitment by countries that has to fulfill, and the agreement establishes requirements, but this will depend very much on internal organization and internal structure in countries.
Thank you for that answer, both of you. So Daniel, do you want to say something? Go ahead.
Yes, just to close, and I think it's important when Andrea said that, of course, there is no one size fits all, especially in the region. given the challenges. I will say that any mechanism obviously has to observe any basic human rights principles, principle of equality, non-discrimination, secure accessibility in all aspects, accessibility for people with disabilities and accessibility to the terrain. Just make sure, like any mechanism that will be implemented that observes basic guarantees of human rights, I think that's the main goal. So that I will just like to like reiterate that point because I think it's important, especially in the context of the region. Thank you.
Great, thank you. The second question comes from Marcela Torres. She asks, given the nature of the instrument as a binding instrument, is there any mechanism to deal with states that have ratified but failed to comply with the agreement, or with complaints from defenders on how states are complying or not, I may add, with its obligation? Maybe Daniel, could you start with this one?
Sure. Thank you, Natalia, and thank you, Marcela, for your question. Basically, it's Article 18 of the agreement. It's the Committee to Support Implementation and Compliance. The committee has to be established, and the rules and procedures of this committee has to be established in the first conference of the parties. As I said, it's going to be 1 year from the ratification of the, no less than 1 year of the entry to force of the agreement. We will have to see how this committee will work. However, it's important to set out that the agreement says that this is a committee that is non-judicial and not adversarial. So it's a more of a advisory role that this committee will have. Regarding settlement of disputes with the provisions of certain parts of the agreement, it basically calls that it will be the submission of dispute to the International Court of Justice, or within a procedure of arbitration before the conference of the parties that will be established. So that will be one of the mechanisms, but there is also available the Inter-American system. If certain provisions of the agreement also, of certain provisions of the agreement dialogue with other inter-American norms, we will see if either the Commission or any other state will, or any organism of the OAS, I don't know, will eventually like an opinion from the Inter-American Court in relation to this matter, for instance. That's a possibility that could happen. But that will be there is already a mechanism to overwatch the implementation.
Thank you. Maria Antonia, Andrea, do you want to say something? No?
No, I think Daniel answered it perfectly well.
Great. Then we can move on to the next question, which are actually two questions from Mario Aguilera. The first question he poses is, considering the increasing number of metal mining popular consultations in the region, how do we explain the use of direct democracy mechanisms instead of procedural environmental rights, which are already recognized in the constitutions of several Latin American countries? And how popular consultations and referendums related to the use of natural resources impact the implementation of the Escazú Agreement? Maybe Andrea, you could start answering this, or Maria Antonia, or whoever. You're muted, Andrea.
I'm sorry. Thank you for the question, because I mean it's an important point and it's very challenging, no? In terms of yes, there are a lot of extractive processes in the region at this time, and the different mechanisms in place for public participation. I think that a very initial but clear understanding is that they are not enough in terms of ensuring substantive participation from people who will be impacted. And this is why we see the big socio-environmental conflicts in the region, and how this, because this is not taken care at the proper stage, then we see litigation in the region increasing with regard to socio-environmental conflicts and many extractive industries. So I cannot say that, I mean, procedural rights should be applied, and there is that requires political will, and that requires enforcement of legislation already in place, which in many cases is not enforced. So we need to continue working in with the chain of enforcement of environmental law in order to strengthen capacities and to put and to have authorities in place that really comply with the regulations. And I think that this is the way in which we will see a decrease in environmental conflicts in the region, and again, and it will also increase trust that is already broken in many places in the region, unfortunately, between from people who then channel the request in a direct way, and in some cases leading to situations of violence and affectation to human rights. So I think that it is important to build capacities, to strengthen capacities, to have political will and accountability of public authorities on the commitments that they already have from the legal frameworks, and also now from the Escazú Agreement.
Thank you, Andrea. I think we have time for one more question, which we actually have in the chat box. This one comes from Angela Kariuki, and she asks, are there any positive actions on protecting environmental and human rights defenders that are being taken by other countries in Latin America and the Caribbean region who may not already be a party to Escazú? Maybe Maria Antonia or Daniel could answer this one.
Daniel, do you want to start?
I mean, yes, I think I will be very brief with this one. As I mentioned earlier, any specific mechanism we have not identified that that certain countries who are not part of the agreement have implemented. In general, for instance, Colombia, although is a signatory but not a part yet of the agreement, has a process in place for the protection of social leaders, but it has been very questioned at the moment by civil society, especially. And it, as I mentioned earlier, this is part also of the demands of the social rights protests that have been going on for the past month. And I think it's gonna be also one of the points that maybe the Commission will observe, but I'm not certain of that aspect. In certain parts of Central America, some countries in Central America have put in place security measures to provide protection to environmental defenders, but they're not sufficient. Even Mexico, which is part of the agreement at the moment, has tried to put in place not only for environmental defenders, but for human rights defenders in the whole country. But the numbers are there. It has not been enough, and I mean, any mechanism, whether it's part of the agreement or not, has still to be revised, I think, by the international community or by the country itself as to the effectiveness. But personally, I haven't seen any specific impact, any specific measure from any country, either part or not part of the agreement, that has been successful to a measure to protect environmental defenders.
I think I'll just add to that I think the prosecution of any acts of violence or threats against environmental defenders is particularly important here as well. I did some work for Global Witness a couple of years ago, and it was interesting because we did an investigation to see how many prosecutions actually came out of the killings that they, the Global Witness publishes every year, those reports, and looking into those and see how many prosecutions actually happen. And it's astounding how little actually came out of the information that was included in those reports. So the government really knows about those things and doesn't do much about it. So obviously there's the whole aspect of preventing anything happening before, but also the aspect of what happens later, because that also helps in preventing any violence against them as well.
Thank you very much. And I think this is a good place to end our class today. We want to thank you, all of you, again for attending and for listening to these brilliant minds. And thank you to the three of you for, again, such an amazing class where I'm sure we all learned a lot. And thank you as well to GNHRE and UNEP for bringing us together. It has been like a real pleasure. Thank you, Dina and Angela, for all your work. And I hope to see you soon.
Can I add, thank you, Natalia, for her great moderation of this session. Thank you very much to our panelists. Thank you to all our participants for your fantastic questions. We have 4 fantastic panels tomorrow. So have a look at the website and we look forward to seeing you. Bye, everyone.
Thank you.
Thank you. Bye, everyone.
Thank you. Thank you very much.
Thank you very much. Thank you. Have a nice evening. Bye.
You too.